5, 4, 3, 2, 1. Learned counsel for the petitioner while seeking to challenge the impugned order dated 7/8/2019, whereby the application of the petitioner for grant of firearms license has been rejected, contends that a perusal of the order impugned would indicate that the district magistrate has indicated three reasons while rejecting the application of the petitioner, namely: A. No reasons have been assigned by the petitioner as to why he requires the firearms license. B. There is no report of actual requirement of arms license from the authorities. And C. There is no threat perception to the petitioner. Learned counsel for the petitioner contends that a perusal of the order impugned would indicate that the inspector in charge of the Kovalinagar Pratapgarh as well as the Tehsil authorities have been submitted their reports as finds place in the order impugned, whereby it has been indicated that the petitioner is a fit person for being granted an arms license. It is contended that the grounds taken by the district magistrate while rejecting the application of the petitioner for grant of firearms license are totally alien to the provisions contained in Section 14 of the Arms Act 1959, hereinafter referred to as the Act 1959. Elaborating the same, the contention of learned counsel for the petitioner is that Section 14 of the Act 1959 is couched in negative terms, that is, the circumstances in which refusal of license can be made. He contends that none of the grounds as have been indicated by the district magistrate while rejecting the application of the petitioner for grant of firearms license fall within the ambit of Section 14 of the Act 1959, and as much as on this ground alone the order impugned merits to be quashed. In this regard, reliance has been placed on a judgment of this court in the case of Ramesh Kumar versus State of UP and others, passed in Writ C number 16543 of 2011, decided on 24/6/2011, to argue that in similar circumstances this court has categorically held that grant of firearms license is not a largesse, and a person is entitled for grant of said license on his own right. On the other hand, learned standing counsel, on the basis of averments contained in the counter affidavit, argues that a perusal of the order impugned would indicate that the competent authority has not found the petitioner to be a fit person for grant of firearms license, in as much as there is no threat perception against the petitioner which has come up in any of the reports that were called for prior to considering the application of the petitioner for grant of firearms license. It is also contended that various government orders have been issued which detail the method on which firearms license is to be granted to a person applying for the same. Thus, it is contended that there is no infirmity or illegality in the order impugned, and the writ petition deserves to be dismissed. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है.